My name is Reagan Smith. I'm General Counsel of the Copyright Office. We are on day 4 of our hearings for the Section 1201 rulemaking. And this session is proposed exemption class 13 regarding adjustments to the current regulatory exemption for security research. So I think most but not all people may have watched previous sessions, but just to go through a bit of how it will work. The government participants will be asking questions, and if you wish to speak, we have found it works a little bit best if you can use the Zoom raised hand feature. But if that's not working for you for one reason or the other, you can raise your hand in the physical world and we'll see you or indicate in the chat. We do have a lot of issues to cover, and so we'll try to provide a brief roadmap and make clear what the questions are, but if you can please try to stick to a short answer to the question posed. I think that will help us clarify and refine the record that we have. We have read all of your comments. We appreciate those comments, and we're looking forward to building on that through today's oral discussion. And we have 3 sessions today. So if you are watching, it is the same link available. You can stay on it. The last session is what is called the audience participation session. So if anyone who wishes to speak on a particular class, if they're not a panelist, you can sign up using the SurveyMonkey link, which is being provided in the chat now. I think our sign up cutoff for today is at 12:30, although we will have another audience participation session April 21st, which is the last day of our hearing. So we're asking that comments for those sessions be limited to around 3 minutes on any of the topics at issue in the rulemaking. For those who are panelists right now, keep in mind that this session is it is being live streamed, and it will be recorded for posting on copyright.gov, as well as transcribed by a court reporter. So please try to speak clearly and mute your audio when you are not speaking. So now I think from the government side, we will introduce ourselves. If we could have Mr. Amer, Mr. Greenberg, and Ms. Kern.
Good morning, Kevin Amer, Deputy General Counsel.
Good morning, Brad Greenberg, Assistant General Counsel.
Melinda Kern, Ringer Fellow.
Thank you. And Mr. Zambrano Ramos.
Hi, everyone. This is Luis Zambrano Ramos. I'm a policy analyst in NTIA's Office of Policy Analysis and Development.
Thank you. And now we will introduce those panelists who are in support of an expanded exemption. So Mr. Adams.
Stan Adams, Center for Democracy and Technology.
Thank you. Professor Halderman, could you please introduce yourself?
I'm Alex Halderman. I'm Professor of Computer Security at the University of Michigan, and I'm a computer scientist.
Thank you. Professor Reed and Mr. Scarberry.
Hey, good morning. Blake Reed, Director of the Samuelson Glushko Technology Law and Policy Clinic at Colorado Law. We're counsel to Professor Halderman, and I'm here with my student attorney, Wilson Scarberry. Wilson?
Hi, I'm Wilson Scarberry. I'm a 3L and a student attorney at the Samuelson Glushko Technology Law and Policy Clinic here at Colorado Law. Thank you.
Thank you. Mr. Williamson?
Hi, Aaron Williamson. I'm here representing the Software Freedom Conservancy.
Thank you. Now, those who have filed comments in opposition to aspects of the proposed adjustments, if we could go Mr. Ayers, Mr. Moore, Mr. Reed, Mr. Troncoso, then Mr. Williams, so that is alphabetical. Please go ahead.
Ms. Smith, this is David Taylor. Mr. Ayers will not be here today. So David
Thank you.
David Taylor for both DVD Copy Control Association and the Advanced Access Content System Licensing Administrator.
Thank you for reminding me, Mr. Taylor, and apologies for not catching that. Mr. Moore?
Chris Moore, Vice President and General Counsel, SIA.
Morgan Reed,
President of the App Association and the Executive Director of the Connected Health Initiative.
Christian Troncoso, Senior Director for Policy at BSA, the Software Alliance.
Good morning, Matthew Williams from Mitchell, Silberberg, and NUP. I represent the joint creators and copyright owners.
Okay, so thank you all for being here today. I guess the first question I have is, this is the sort of third time we have looked at the need for a broader regulatory exemption for security research, which has been in place since 2015, compared to the statutory exemption. And, you know, just keeping it to a minute or so, because we will walk through some of the issues. I'm wondering, what are the main concerns with how the current exemption is operating, or main concerns with broadening it in the ways requested through some of the submissions? And so if you would like to speak to that, just indicate with the raised hand button.
So I don't see the raised hand button. I apologize. I'm usually quite savvy.
Okay, well, if you just wave, go ahead. But if you would like to speak, Mr. Williamson, go ahead.
Okay, so Software Freedom Conservancy is here primarily to comment on the lack of clarity around the scope of the existing temporary exemption as it applies to privacy research activities. There have, that our comment was that it was not clear that privacy research that is not specifically about a security flaw or vulnerability is covered by the existing exemption. There have been some comments back and forth on whether those activities fall into security research. And so we seek clarity around that question primarily.
Thank you. And are you aware of projects that have not been taken up due to this alleged lack of clarity? And if so, could you describe any?
I cannot name a specific project that has not been undertaken because of this lack of clarity.
Thank you. Any others who wanted to speak to any overview issues? And otherwise, I will turn the questioning to my colleague, Mr. Greenberg.
Ms. Smith, I had my hand up, and I believe Mr. Adams did before me.
Okay, well, I'm wondering if maybe there is something going wrong on my end. But how about Professor Reed, then Mr. Adams?
Thanks very much. Appreciate that, and sorry for whatever the malfunction with the hand raising tool is. We'll try waving. I would just underscore. I think the one of the main concerns that we hope to address today is the continuing inclusion of the other laws limitation, which, as the Department of Justice pointed out, really transforms the legal risk that security researchers who are trying to structure projects face, and we hope we'll have an opportunity to discuss the Department of Justice's changed perspective on the other laws exemption, and talk about whether we could better serve the needs of cybersecurity policy and better serve the needs of security researchers by removing the explicit tie between Section 1201 and every other law, which includes not only laws like the Computer Fraud and Abuse Act, but laws ranging from local ordinances, state statutes, all the way up to potentially foreign laws. And again, that's something that significantly complicates the risk calculus for security researchers. Thanks.
I'll just jump in to say that Professor Reed covered most of my points already, but wanted to say we see the inclusion of the conditional tie to the CFAA as the biggest adder of risk in the current exemption. Thank you.
Okay, thanks. And in part because I'm not seeing the raised hand button, I asked everyone to use. I'm going to turn this to Mr. Greenberg, but I know that the other laws exemption is something where we're eager to get into that in particular because we also received a letter from our colleagues at the Department of Justice that we want to make sure we can narrate. Okay, so Mr. Greenberg.
Thanks, Ms. Smith. So I'll just say I am seeing your raised hands, so rest assured that does work if you hit the button on my end at least. I also want to say that the DOJ letter and the other laws condition is one that we have a lot of questions on. But before we get to that, we'd like to start with some other questions. And if we could sort of set aside the DOJ letter until we get to the other laws portion, it would probably be helpful for the filling in the record on the other limitations that have been requested to be removed. I also do want to caution, this is a pretty large panel. So I just ask that everyone try to keep their responses specific but tight. So just starting with a high level question, I wanted to raise that in the reply comments, proponents argued that opponents have provided no evidence beyond baseless speculation, nor is there any reason to expect that these concerns, the concerns related to infringing uses, if the exemption was expanded, are likely to materialize. At the same time, the opponents said something similar with regard to adverse effects and the fact that the chilling effects specifically that the proponents speak of, they found to be also largely speculative and not based on clear evidence. So I just wanted to ask, before we get into what is the additional evidence we have in the record for 2021 vis-a-vis 2018 and 2015, I want to ask the panelists, what is the appropriate degree of weight that you think the office should give to speculative concerns rather than concrete or proven or demonstrated harms? Mr. Reed, Mr. Blake Reed, Professor Reed.
Thanks, and Morgan and I will try and disambiguate each other throughout the hearing. Thanks for your patience with that. I think we've been doing hearings on security research for a long time. I think Professor Halderman and I were first here back in 2008, and I recall concerns about the security research on video games leading to a flood of piracy that never materialized. I think those concerns came up with the audio CD security research exemption back in 2005, and have been variously raised about everything from applications on smartphones to enterprise software to everything else. And so what I would encourage the office to consider is that the speculation isn't just speculation, but it's repeated speculation that has never borne fruit, has never materialized, has never, to the best of my knowledge, resulted in any sort of litigation where anyone was able to raise even the presence of the exemption as an excuse for infringement. And I think on the flip side, you've seen over the years, as the office has broadened this exemption, gradually and incrementally removed some of the limitations on this exemption, researchers like Professor Halderman have actually been able to do a lot more. And as cybersecurity of our nation's most vulnerable systems, such as election systems, has become more and more paramount, researchers have really been able to do more because of the increased certainty that simplifying this exemption provides. So I'd encourage you, as you're thinking about speculation, I don't think the speculation cuts evenly both ways. I think the lowered risk has improved our nation's cybersecurity, and the concerns about infringement and violation of other laws have never materialized despite more than a decade of claims that they would. Thanks.
Okay, thank you, Professor Reed. I'm going to go just across the top of my window. So Mr. Moore. Can everybody hear me okay? I'm having some bandwidth issues too. Yeah, okay. So I think we may have lost Mr. Moore. So Professor Halderman.
Can you hear me now?
I can, yes, thank you.
Okay. Mr. Halderman, go ahead.
All right, thank you. So security researchers really do face legal uncertainty that is holding back our work on the basis of these problems with 1201. And let me give you just one example of that. just 2 weeks ago at my department's faculty meeting. I have a colleague who's an assistant professor, who's a star security researcher, who started talking about work that he's trying to do, exploring a very important new class of vulnerabilities in computing systems. And as soon as he got through about 2 sentences of description, 5 different senior faculty members said, whoa, wait a minute. This sounds like it might touch on the DMCA. You've got to find a lawyer, and not just university counsel. You need to find the kind of lawyer who understands the full breadth of the DMCA. So what is my junior colleague having to do? It's not enough to just simply go through normal university process, make a quick phone call to the OGC. He's going to have to go and find an expert on this area of law, perhaps on other areas of law that touch on the broader context we're talking about with the other laws provision. And he's going to have to do that rather than spending his time actually advancing the science of computer security and trying to help keep everyone safe. And this is what it looks like from the perspective of faculty, who are some of the most privileged and well-resourced security researchers. When it comes to the broader community of people who are just students getting started, people who are amateurs, who are making real contributions to the field as in their free time or as part of a hobby. These people don't have the kinds of resources that we do, and probably will never get to the level of confidence and that a professional or an academic researcher would be able to have. So all of this is unnecessary. There's no actual infringement that is resulting from the kind of research that I and my colleagues are talking about. But we're facing significant uncertainty, spending far too much of our lives talking to lawyers. No offense to the lawyers in the room, but it's time that we should be spending advancing security and keeping everyone safe.
Go ahead, Ms. Smith.
I guess could you speak a second to the delta, right? Because there already is an exemption. So we can't change the DMCA, and we have adopted an exemption trying to meet the needs of good faith security researchers before. So part of this, I'm trying to figure out what the Copyright Office can do here.
Well, so a large part of the exemption of the problem, as we've explained, comes from the various complicating factors in the existing exemption, including the other laws provision, which makes it just so much harder to take to have a brief overview of someone's project and be able to determine whether it's safe to proceed. So it's in my experience, and the experience of watching colleagues who have gone through this, the problem is not that there's no exemption. The problem is that the exemption has so many caveats.
Mr. Moore.
All right, I think I unmuted myself, so hopefully I am not monologuing. So a couple of points. I mean, I think the fact that, look, a lot of these ecosystems, whether we're talking about the kinds that surround content or whether we're talking about cloud ecosystems, require tremendous investment, and they are expensive. And they are, as our friend just pointed out, being explored by people who are well-trained and highly ethical, but can be, and those who would hope to become well-trained and hopefully highly ethical. But they are also open to exploration by those who are not. And so that's something that I think Congress recognized when it set up these exemptions in the first place, that this was likely to be the case. And so in terms of the weight that the Copyright Office is supposed to give evidence or, the lack of it. I mean, I would point out a few things. I mean, one is that if there are statements in the record that I can't think of anything that's been actively thwarted or chilled, that to me would be fairly probative of a failure to meet the burden on the petition. The other thing that's helpful to know, I think, are the kinds of activities, is the affirmative case on the other side, which we rarely hear about the sorts of things that the text of the petition has actually enabled. And there is a difference between saying, well, we need specialized advice to get through this, to understand what the ramifications of a particular course of study or inquiry are, and the statute actually chilling it. The presence of a legal issue is not chilling. We don't think that should be viewed as chilling. What the statute requires is that it impede it, and its mere existence, or the fact that you have to comply with it and figure out how to do that, whether or not you can do that, that's not chilling. What's chilling is, theoretically at least, hey, I've got this clear, fair use that I can't do because of the following factors. And that type, I mean, I think you've been through, like you said, we're in a bit of a Groundhog Day here. But this is an exercise that the office has been through before. And I'll have other comments on the other law provisions and so forth, but on that's the question, I think.
Right. Mr. Taylor?
Thank you, Mr. Greenberg. I think that's a very difficult question to answer, because it's asking us to prove a negative. And what we have seen so far is what we have in place legally seems to work. We spend a lot of time chasing after people who would put products in the market based on this research, that could put this products in the market based on this research that they do. And so far, we don't see a link to that. And that's probably because the exemption that the Copyright Office has repeatedly made has worked effectively. So it's kind of, again, hard to prove a negative. And I would just quickly respond to this need to hire an outside lawyer specialist. I think that the recommendations of the register are very clear on the proposed opportunities or uses that the proponents want to make. And I don't see where there could be any uncertainty that someone with an advanced degree could not simply read for themselves what is allowed and what is not allowed. So thank you.
Mr. Scarberry?
Yes, to just briefly respond to a couple of things that Mr. Taylor and Mr. Moore said. We've also identified the use limitations that the multiple references to solely and primarily that significantly cabin security research. These create problems as far as ancillary activities related to security research, such as scholarship and criticism, that we think is problematic. I'd also like to note that in Mr. Taylor's example, he claimed that security researchers might try and then use the products of their research to openly compete. Now, if that was a clear case of infringement, copyright holders would have alternative remedies to obviously go after those folks. But in the recent case of Corellium versus Apple, the court found that Corellium's use in that case was a fair use. So even in that instance, it seems highly speculative that security researchers are going to be going out and trying to turn the results of their research into competing products.
Great. I'm actually going to go to our colleague at NTIA. There's something you wanted to add?
Oh, thank you so much. I guess this question is to Professor Halderman. Professor, could you talk about the role that transparency plays in the security research community? Things like writing research results, sharing investigational techniques. Just how important is that to the development of the research community? Thank you.
Sure, I'd be happy to. Transparency is often at the center of our work. We seek in general to improve security for the public at large. And there are two main ways that we do that. One, many researchers discover vulnerabilities in specific products or specific tools and protocols, and we work behind the scenes to get them fixed. But then usually after the problems are fixed, but not always, but usually after they're fixed, researchers go public with the results of their findings. And that's not only to disseminate knowledge to the broader research community about how similar problems would be found, but it's also to alert the public about the problems that have existed, so people can make better choices in the future about what products or services they want to buy or rely on. So we have most of the, in the vast majority of projects I've worked on, they've resulted ultimately in some kind of publication that described the findings and what we did. And that's just core to the academic mission of a university.
Professor Halderman, if I can
yes.
just interrupt you, and I apologize to the hands that are up. I know they're still up, but this will actually, I want to jump ahead then, since you're sort of getting into the use limitation and purpose. I have a question I was already going to ask related to the registrar's past recommendations. In both 2018 and 2015, the registrar clarified that the access limitation does not prohibit teaching, academic dialogue, or scholarship involving the information derived from good faith research. The question I have is what evidence is there of security researchers not actually sharing what they've learned via teaching or academic dialogue or scholarship because they're afraid that that will exceed the bounds of the exemption simply because it's not part of the CFR, even though it's part of the registrar's recommendation?
You'll have to give me a minute to process your question, I think, but maybe someone else from our side wants to jump in while I do.
Professor Reed, do you have thoughts on that?
I had thoughts on something else, but I saw Mr. Adams wanted to jump in.
Okay, Mr. Adams.
Thank you. Yeah, I was just going to say, former colleague of mine, Joe Hall, also computer security researcher, and I did a report that we submitted for the record last year, indicating that many security researchers do fear coming forward with their research. They fear coming to the vendors for out of sort of retaliation risk, and they fear making it public for the same reason. And so, we I believe included this as an attachment or a footnote in our comments this year, but we also had it in the record last year that this is a documented fear here, that sort of publicizing results draws attention, and often of the wrong kind, right? Not the great thanks for helping solve this problem, but now we're going to seek legal action against you for making this public.
Mr.
Well, I guess,
Go ahead, Ms. Smith.
I hope, Mr. Reamer, we can sort of keep teeing this up and probe in on it, because what we did in response to those comments last time was clarify an administrative guidance, which was intended to be used, that a researcher who at the time of circumvention intends to publish the results of good faith research or use in teaching would not ordinarily exceed the bounds of the access limitation. So the office is not authorized to grant an exception to the service bar if we're getting over into that end. So that's, I think, why we are trying to figure out what particularly is not operative in light of that existing additional guidance we provided in 2018. So I guess maybe we could hear from Mr. Troncoso and then keep probing this issue.
Thanks for letting me jump in. I fear that what I'm about to say is a little bit repetitive at this point, but just to make the point that for BSA and our member companies, they want to engage with the independent security research community, and they often do. So they have a real vested interest in there being a very clear exemption to facilitate this type of activity. As we look at the 2018 exemption, it seems sufficiently clear to us that there are not limits on post-circumvention activity that would in any way inhibit the type of scholarship that Professor Reed and Professor Halderman are interested in pursuing. So in the absence of some sort of demonstrated, evident case that that this language is unclear, it seems to us misguided to try to change it at this point. To the extent there is clearer language, we would be open to, discussing that. But, we think the exemption right now is fairly clear on that point. I think the other, difficulty in this space is that, it sort of straddles the line between prohibitions on acts of circumvention and the trafficking prohibitions, which this rulemaking, unfortunately, for better or worse, is not sort of equipped to address. So to the extent like the concerns lay there, I'm not sure that we're going to be able to resolve them through this rulemaking process.
Mr. Troncoso, are you referring to the concerns that if you have dialogue, I think it's what Ms. Smith was saying a minute ago, but if just for the record, if you have dialogue based on good faith security research that then would enable somebody else to.
Yeah, I'm not suggesting that's my interpretation of the DMCA, but it seems to me that, we're sort of skirting around that issue in terms of whether some of this research activity may create issues there, right? To the extent that that's where the uncertainty is, unfortunately, the Copyright Office probably isn't able to resolve that issue.
Can you tell us what the value is that BSA sees in the solely limitation, what work that does?
If the limitation is not limited to activity that's undertaken solely for the purpose of security research, what is the exemption? What does it then cover? Would be our sort of question. We don't see this as a sort of an overly restrictive limitation. The proponents want an exemption for security research. They've got the exemption is specifically for security research. If the activity they seek an exemption for is broader than security research, I think we need to have a sort of more candid discussion about what those activities are.
So I didn't see, to the proponents, I didn't see in submissions any reference to some other kind of limiting principle like primarily or something like that. But I did notice in GitHub's reply comments, they talked, they were looking for something that definitely was beyond solely, referencing the fact that there's ancillary benefits to good faith security research, and good faith security research is often about many, or computer research is often about many things. And then quote, the exemption should not be limited to only one purpose, but should provide enough flexibility that ancillary and beneficial activities consistent with, but not limited to, good faith security research continue to fall within it. To the other proponents, I just want to know, A, do you have a different limiting principle besides solely that I just missed or forgot? But B, to what extent, do you share GitHub's feelings here that the exemption should cover more as long as it sort of shares similar principles or values to good faith security research? I actually can't tell at this point who wants to talk because hands have just been up for a while. Professor Reed, there we go.
Yeah, I'll be happy to take that one. Mr. Greenberg, I just observed that I didn't hear an answer to your question and Mr. Troncoso's response there. To the point that GitHub raised, I think what you're hearing there is that this is not just a concern for academic researchers, but this is a concern out in industry, that when folks are doing work like securing a supply chain that's integrated with other aspects of a business, these same sorts of concerns that we're talking about here are prevalent there as well. But I think the important point to center on here, and I want to respond to Ms. Smith's question about the guidance, that guidance is extremely helpful if you have access to a lawyer who can go read a several hundred-page administrative record and figure out how it applies in your case. I would also make the observation that if you have a lawyer like that and you're probably doing research that is going to implicate the interests of some fairly large companies who may be fairly litigious. And one example of a company like that is Apple. And if you look at the Corellium case that Apple just brought, what you see, and this is the context of the trafficking ban, so I don't want to be careful to cabin the analogy. They're talking about the use of the word solely in the context of the trafficking ban. But what you see is Apple picking apart the word solely in exactly the way that we're talking about here.
But we've given no guidance on solely for the purposes of trafficking, because this rulemaking is not on the does not cover trafficking.
Of course. What I'm saying is the fact that even though Apple has basically gotten thrown off of the part of its case that is actually focused on copyright infringement, it's continuing to pursue extremely aggressive action based on stretched interpretations of the word solely. So I guess the message I'm trying to tell you, if you're talking to a sophisticated, if you don't have counsel, you're not going to get this guidance in the first place. If you're talking to counsel, they're going to say, gee, are you going to make a company like Apple mad? Because it seems like a company like Apple might not really care about what the guidance is, because they are going to take you to court and they're going to bully you and they're going to try to shut down your work. And that's why we think taking the language out of the exemption is really important. It provides clarity to folks who don't have lawyers, and it provides certainty to folks who do have access to lawyers that these caveats are not going to get abused.
Sorry, and you would just remove the word solely, or you would use a different word? Can you answer Mr. Greenberg's question whether you have a different standard or not? And then I think
yeah, we think removing the word solely is the right way to go. And I think the way we framed the limitation was, you have an exemption, and I think some of the opponents have phrased it this way: you have an exemption for security research. And if you can say that what we are doing is good faith security research and meets all of the qualifications for that, then you qualify for the exemption. And by doing that, we avoid basically creating a foothold for these sort of abusive arguments that say, well, you might be doing something else. We don't know about the publication of this paper. We don't know. It seems like this is related to a business. You're getting paid for this. We cut off all of these arguments that may well not succeed by the time you actually get to a judgment on the merits in a litigation, but are going to give the ability for a large company like an Apple to come in and basically bring an abusive litigation that's going to shut somebody's research down before it gets out of the gates.
Okay, Mr. Reed, and then Mr. I believe it's Williamson, not William, and then Mr. Williams. I don't think any of you have spoken yet. Sorry about that.
Yeah, thank you. Christian covered several things, but both Professor Halderman and my fellow Reed have harped on the idea that, boy, it's just so hard to have counsel. It's ironic because I run a trade association with more than 5,000 companies involved, and we literally have one of the leading experts on the DMCA as an on-staff attorney, and we regularly get questions from our members about the DMCA, which we provide at no cost to our members. And if you're a small business, so when Halderman says, oh gosh, I just can't find an attorney, my junior associate, well, I'm pretty sure that if he picks up the phone and makes a phone call to any of the trade associations that work in this space, there is a plethora of supportive help from attorneys. And to Blake Reed's point about, well, you don't want to anger Apple, we've actually had our counsel engage directly and quietly with some of the biggest players on some of the questions around this, and engage directly. So I think this, gosh, we just need help because we can't find an attorney. It's a little hard to swallow. I found it interesting when Stan pointed out that Joe Hall, Joe, also know him well, he's literally pre-COVID sat 2 floors below me in almost the same office building. So the community of people who are experts on this issue is one in which it's not hard to find an expert able to provide some insights. In addition, the Copyright Office has done a pretty good job of providing plain English understanding. So I want to kind of cabin that and say, let's not pretend there aren't enough attorneys to find who have understanding of the DMCA. But additionally, I think the one problem, and very sympathetic to the idea of security research, But the problem with the removal of the word solely is it basically removes any value for the words good faith. Because if it's not solely for good faith, then it might also be for bad faith. And that's when we enter into this cascade of opportunity. Halderman said that he was concerned about, there was a sense, I'm sorry, Mr. Scarberry said that it was, that we were suggesting somehow that researchers are unlikely to turn their discovery into a competing product. He's probably right. Most academics are not. But the value of the research that they are doing, if you remove the good faith exception, is 100% going to end up in products that are on the dark web and are available from people who do not have a good faith intent. So I think that's the problem. If you remove solely, you essentially create an entire ecosystem around bad faith.
Yep.
And so I also stipulate to much of what Christian said. Thank you.
Thank you. Before I go to you, Mr. Williams, I just want to point out that if you remove the word solely, part of what I hear proponents arguing for is they need more certainty so researchers know what they can and can't do. But if you remove the word solely, you could also argue you end up with less certainty because there's not a clear limitation. I mean, we have to acknowledge there's a value to plain language, which the office has provided over the past 2 rulemakings with both the rule and then the administrative guidance to help interpret the rule. So I do think that's a place we have to start from, the idea that if we're trying to provide certainty, removing words that have meaning doesn't necessarily give more certainty. Mr. Williamson?
Thank you. I'd like to first address the point that Mr. Reed made regarding there being plenty of attorneys. I have been the attorney for a software trade association, and I've been the attorney for a nonprofit that gave legal counsel to free and open source software projects who couldn't afford it, et cetera, et cetera. There are 2 issues here. The one is that an attorney for a trade association that you're a member of is not your attorney. So you can't get privileged advice from that attorney. And so relying on their sense of what the law is with all of the caveats of I'm not your attorney is not of any comfort to somebody who is potentially risking litigation. And as our colleagues have pointed out in their comments, nonprofit organizations like the Electronic Frontier Foundation that provide counsel to individual developers sometimes when they think the case is important enough, et cetera, are absolutely overwhelmed with requests for assistance. And so, they're not, they can't really be relied on if you have an urgent issue, because they may well just not have the capacity for your case. In my practice, I represent, I advise clients on the DMCA in all its aspects. I advise clients on the CFAA. I defend criminal defendants in CFAA cases. I advise clients on ECPA. And the most common counsel that I give to individuals who are doing something that might run afoul of the CFA or the DMCA is, if you end up in litigation, you're done. They simply can't afford to even proceed to a verdict in district court against an Apple, et cetera. And so
real quick, I think we're spending a lot of time talking about how hard it is to hire attorneys, and I agree with that wholeheartedly, but we could talk about this with regard to almost any civil law. And we don't have a ton of time today. And so I don't want to go too far down this rabbit hole. And any exemption that the office ends up recommending is still going to require an attorney to review it at some point where the researcher gets close to the line. So we can talk about this, but there's a whole lot more value in talking about removing the specific limitations and why. So I just want to caution that if there's more you want to say on the solely on the purpose and use exemption limitations, I would go to that. And then I want to go to Mr. Williams, and then with apologies to Mr. Scarberry, Mr. Moore, who still have their hands up, I want to move to the primary evidence that was submitted with regard to these limitations, because I think that we're going to start running pretty behind here pretty quick because we still have a lawfully acquired and other laws to get to.
So I would like to briefly address solely. If you remove solely, you're left with for the purpose of good faith security research, right? And so, it's a lot easier to tell whether you're doing research in good faith than it is to tell whether you're doing research solely for doing work solely for good faith security research, because as Mr. Reed pointed out, Professor Reed pointed out, those who work in security research are often in a sort of dual purpose role. A lot of them work in companies that are attempting to secure their own systems. And so they're not doing solely research, they're also doing remediation in their own networks. And every criticism I've heard of the word solely from the opposition would suggest that they're looking at bad faith potential uses. And so when you remove solely, I think good faith does all the work that they need solely to do.
I just want to ask this really quickly, but I do want to keep moving forward. Do you think the word primarily would be any better, or would that be just as create, just in your mind, just as much uncertainty and probably it'd probably be, I'm sure, be less palatable to the opponents, but would it be any better of an exemption from the user standpoint?
I think that, you know, it is a small step that contains nearly all the uncertainty of solely.
Okay, Mr. Williams. Unless Mr. Williamson, did you have anything else you wanted to add? I'm sorry, you did wait a long time. Okay, Mr. Williams.
Thank you.
Thank you. I'm going to try to go back to kind of the beginning here, just to address some of the questions. So, you know, I thought the first question was really an opportunity for the proponents, and I think this came from Ms. Smith, to provide some specific examples of chilled projects. And I think we got none. We did get something useful from Professor Halderman, but it had no specifics. There was nothing about why the current exemption would not cover it. I don't know whether his colleagues are overly cautious or being appropriately cautious, but there was nothing that I can assess because there were no details there. So looking at the record, I think that says a lot. There's not evidence that research is being chilled beyond just abstract statements of the kind, Mr. Greenberg, that you referred to about, well, can I get a lawyer or not, which I agree with the point you made on that issue, so I won't dwell on it. Like BSA, my clients think security research is important. We did not oppose renewal here, but with no substantive examples of chilling effects from the current language, we don't understand why it needs to be changed. On Apple versus Corellium, that's a project that moved ahead. It's a commercial project that moved ahead. And my understanding is that they'll go to trial and that will be tested, the limits of this exemption perhaps, and also of the statutory exceptions. And we hear in this proceeding repeatedly that there's no test cases, there's no lawsuits, there's not enough lawsuits for us to prove our case of chilling effects, or that the statute needs to be changed. But then if someone does file a lawsuit, and I'm not representing Apple here, but if someone does, they're accused of being a bully and of being excessive with their use of the law. And so there's no way to win in that scenario where on the one hand, people beg for lawsuits, and on the other hand, they criticize them. On the issue of speculation, I think it was your question, if I recall, Mr. Greenberg, what should be the standard here? I think speculation from the proponents is demonstrably not sufficient for them to meet their burden. The burden is initially on them. You can consider our concerns about the scope of exemptions to be speculation. And Professor Reed said, oh, there's no evidence of piracy. And he went back to things that happened, 15 years ago, 12 years ago in terms of proposals. But as Mr. Taylor, I think, said, proving a negative is very difficult. And us knowing where the piracy comes from is very hard. And so I think when you're talking about speculation, yes, ideally on the opposition side, you'd have specific evidence of harm. But I think it's common sense that if databases and things of that nature are breached, there's a potential for harm, whereas there's no there's no specifics on the proponent side, and that's where the burden lies in this. And as I said, we support the renewal of the existing exemption. We're fine with it being renewed. They already have a very broad exemption, and so we don't see the harm coming from it. I will just mention very quickly 2 points. One, even the discussion draft that came out of the Judiciary Committee process recently incorporates all of the items, I believe, from the existing exemption that the proponents are criticizing. And I testified on the same panel that Professor Reed did. I know that the members of Congress took that seriously, and the discussion draft seemed to endorse the office's approach to this exemption. And so I would just say that in that separate forum, there was also apparently not enough evidence to justify changing this proposal. And finally, I do just want to mention that there's some discussion of the Green versus DOJ case in the comments. And if we have time, I would love to get a chance to speak.
Yeah. So that's actually where I'm going to go next. I do first want to clarify 2 things. One is that the Digital Copyright Act discussion draft that came out of that process would have granted exemptions for trafficking also. So it does overlap a little bit here with the concerns of the proponents. I do also want to note Mr. Adams' point about the report that he had previously submitted regarding fear, not which is again more anecdotal evidence, but fear among some researchers about what they share. Mr. Adams, for your clarification, I just checked all 3 of the submissions that CDT was on, and I don't see it appended to any of that from this process at least. So I do want to ask next, and I will start with, well, I want to actually ask the question first. So the primary legs example of an adverse effect from proponents is that is different from what was present in the 2018 record is the June 2019 ruling in Green v. DOJ. And I'm wondering, both for proponents and opponents, how much stock you think the office should put in that decision. I do want to note that on page 8 of the proponents' reply comments, they referred to the Green decision as a summary judgment motion. It was, in fact, a motion to dismiss, which is a different burden for the plaintiff. So I'd like to hear from proponents and opponents as to what the office should do in terms of interpreting the June 2019 decision in Green v. DOJ as evidence of a chilling effect from the circumvention prohibition. I'll start with Professor Reed and then Mr. Taylor.
Thanks, Mr. Greenberg. If I could, before I move on to Green, just wanted to make one quick response on the solely and primarily language, which is, I think the one core concern that we hear that is cognizable under Section 1201 is when within the ambit of the office's jurisdiction here is thinking about copyright infringement. And I note that there's a limitation in the existing exemption that restricts use of the information that's derived from the security research in a manner that facilitates copyright infringement. Now, we have concerns about the formulation of that particular limitation because it puts responsibility on basically for downstream third-party behavior, not of the researcher. We don't think that formulation is right. But to the extent that the office wants to focus on extraneous concerns or bad faith, as Mr. Reed put forth, thinking about making sure that those concerns are actually narrowed to concerns of copyright infringement, I think is important. And I think it is really important, contrary to Mr. Williams' point, to focus on the fact that there's absolutely no evidence in the record of copyright infringement being a problem in the more than a decade that this exemption has basically been in the works. To the point about Green, and I think this actually ties to the discussion earlier about why can't you just hire a lawyer lawyer? Why can't you get the guidance that you need? You need to jump through a bunch of threshold hoops to go about doing your research here. I think the sort of criticism of of Professor Halderman and his colleagues and so forth. I think what Green versus DOJ underscores, and it should serve as a strong reminder to everyone here, is that what's being chilled here and what's at stake here is First Amendment protected speech, right? So in other words, we can look at a lot of the different activities that are being discussed during this triennial review, but there are very few that are so poignantly and directly directed at criticism of a critical speech that's aimed at products that frankly have often a direct role in the administration of our elections, of our democracy, that take on salience of a deeply political nature in some cases. And so we think the salience of Green versus DOJ is incredibly important for the office to remember that any overreach of this exemption, any way in which this exemption chills research, is stepping on the First Amendment toes of folks who are engaged in core First Amendment speech. And that's what the court is getting at there. I think the office should heed what the court had to say there as a warning, to say, if you want to salvage Section 1201, if you want to make sure that Section 1201 as a whole doesn't come under constitutional scrutiny, it's incumbent on you to make sure that the exemption is drawn in such a way that it minimizes any ancillary effects on First Amendment protected speech. And so we think that's a really important recognition of some of the same adverse effects. And by the way, I'd point out that we brought many of these up in 2015 and 2018, and that the office chose to dismiss them in those triennial reviews. I would treat this as the court sending a message to the office. It is important to retract the exemption to make sure that the First Amendment isn't implicated. Thanks.
So thank you, Professor Reed. I'm not here to comment on your statement because, as we have all noted, right, it is an active litigation. But I do want, because of that, to sort of make sure we're clear on what has been said today, which is not that the Copyright Office has said, why not just hire a lawyer? But we have pointed out that we have provided administrative guidance that professors are able to publish the results of their good faith research or use them in the course of teaching. And that's just a quote from 2018. So I just want to be careful on that. And in terms of what the current exemption already permits, as the agency has clarified. Okay, Mr. Taylor.
Thank you. Before I turn to the question on Green, I just want to clarify a point that was maybe misunderstood. We certainly have no problem with responsible computer security researchers. I think Mr. Morgan clarified that it really is who can take advantage of that research and making sure that it's responsibly handled. The second thing on the solely, I think solely really is there because this rulemaking has to follow the record. And well, I too read the reply comments and thought, well, perhaps some of these additional activities still could fall under good faith computer research. Now, turning to Green, I would just simply say that, you know, it's a motion to dismiss. And we have long recognized that the DMCA poses First Amendment issues. I mean, to say that you can raise a cognizable claim is very clear since Corley. And the facts have to be developed on the record and there has to be a final ruling. But even if the court does decide for whatever reason there is a First Amendment issue here, there are far more cases out there that suggest that the DMCA does not raise First Amendment concerns. So at that point, if the court were to decide, it would still be an outlier for the jurisprudence in this area. So I think it's a very far stretch for Mr. Reed to suggest that the Copyright Office should take the ruling on the motion to dismiss as a signal as to what is the correct way to interpret the exemptions and the exemption process in context of the First Amendment.
Okay, thank you. Mr. Williams?
Yeah, thank you very much. On the Green case, as a couple of you have touched on, I mean, the procedural posture is quite different from how the case is characterized in the proponent's comments. The comments, I think, say that Judge Sullivan said there was a compelling case of a First Amendment violation, for example, that none of that is in the case. It was a motion to dismiss. He repeatedly stressed that the government on that posture had the burden. They are now on a preliminary injunction motion that's been pending for quite some time. The burden is going to shift. I find it quite interesting that when Judge Sullivan asked for the parties to come to some agreement on how to move forward with discovery, the plaintiffs didn't seem to want discovery. They wanted to jump right to this preliminary injunction motion without any discovery. And I don't think they have enough evidence, but of course that will be up to Judge Sullivan, but he certainly did not hold in any shape or form that the DMCA generally or the specific security research exception in this proceeding violates the First Amendment. And so I believe under First Amendment scrutiny, under the intermediate scrutiny standard, that this exemption as well as the statute generally should survive. But the comments vastly overstate the impact of that motion to dismiss decision.
Okay, thank you, Mr. Williams. I want to turn now to lawfully acquired before we move on to other laws. And again, to the proponents, I'm wondering if you have any examples of researchers being discouraged from conducting good faith security research because of contract terms that limit the ability for a security researcher to acquire the software or device. As you are aware, into the 2018 recommendations of the Acting Register, there was clarifying language here and support from DOJ on our reading of the exemption so that it would not impose a problem for good faith security researchers. So I'm wondering if in the 3 years since, you have come across examples of researchers who are being discouraged or prevented from engaging in good faith security research because of the lawfully acquired limitation. Professor Reed, I see your hand.
Thanks, Mr. Greenberg, and I'll defer to Professor Halderman if he's got any particular examples. I just wanted to, in the interest of hopefully shortcutting too long of a discussion on lawfully acquired, point out that basically our concerns with lawfully acquired are a subset of the concerns with other laws. In other words, the set of legal issues, the set of risk, the set of uncertainty, the complexity of dealing with it is just, we kind of see lawfully acquired as an example of the kinds of problems that occur with other law, but obviously a narrower subset, a narrower set of laws that are potentially implicated, a slightly simpler question. So just wanted to sort of say our concerns are basically the same as what we've been discussing for the last hour or so, that albeit in a little bit of miniature, if that makes any sense.
Well, can I then just ask as a follow-up, what do you make of the fact that DOJ, and again, we're going to talk more about other laws in a minute, so no need to spend time on that yet, but what do you make of the fact that DOJ does think that the lawfully acquired limitation still serves an important purpose, and coupled with the register's administrative language is not creating significant adverse effects, whereas they do support removing the other law's limitation? What do you make of that distinction?
Well, I think we obviously diverge from DOJ on the salience of the lawfully acquired limitation. I think we come to a different place. Obviously, we're in big agreement that the broader swath of laws that are implicated by the other laws limitation impose a more significant chilling effect. And so I think we are directionally in the same place as the Department of Justice, albeit we come to a different place on the lawfully acquired exemption. My colleague, Mr. Scarberry, may have something to add there.
Yeah, Mr. Scarberry, do you want to add anything? And after Mr. Scarberry, if there's anyone from the opponents who have anything they want to add to why, I know from the reading of the comments, you think that sort of the concern with lawfully acquired is sort of an overly narrow and implausible reading. If there's anything you want to add to what's already in the record there. Mr. Scarberry?
Yes, on the lawfully acquired limitation, our concern here is simply that that clause allows software developers to essentially weaponize the DMCA in a way to totally preclude security research simply by including a contractual clause that devices cannot be resold to security researchers. And we pointed out in our comments, one area where this is particularly common is in the context of election machine security research, where these companies frequently try and dissuade security researchers from analyzing their systems by including these kind of contractual restraints.
I didn't take note of that, so thank you for bringing that up, but I did see that in the comments. Mr. Troncoso?
You know, again, I think that what we just heard runs counter to the clear guidance that the Copyright Office tried to give in issuing the 2018 exemption, where they made clear that the lawfully acquired limitation applies only to the acquisition and whether or not it itself is in violation of law. To the extent there are contractual issues, I don't think that those are implicated in at the point of acquisition. So again, I understand that there is a legal overlay to a lot of the activity that is in play with security research, but we can't, that legal overlay is not going to go away merely by removing the limitations in this exemption. That legal overlay is a natural byproduct of there being a statutory prohibition that can cover this activity and other statutes, so the CFAA and others that I'm sure we'll discuss in a moment.
Could I ask?
Alderman, I'm sure you have something to say on the election.
Sorry, Mr. Greenberg,
Yes.
could I just ask a follow-up question? This is a more general question to proponents, and Professor Haldeman, I see you can maybe incorporate this into your answer if you'd like. But I mean, it strikes me that, you know, sometimes we get criticized in the office for having exemptions that are too detailed, right? That are, you know, and this goes to your concern about needing lawyers to help with understanding them. And so your approach is to just remove all of this language. But I mean, I think we've heard, you know, a countervailing concern from the opponents that by doing that, that could at least suggest that we're in fact broadening the exemptions, right? And that there is a change. And we can say all we want in our recommendation that it's not intended to do that. But from what we've heard today, that doesn't seem to carry very much weight in some people's eyes. So, you know, I wonder how much, you know, so I think we would be reluctant to just sort of take out a lot of language. And so, you know, our approach was to provide clarification in the recommendation. If we were to take the approach of sort of adding language to the regulatory text saying things like, you know, this includes good faith, you know, publication of research results, teaching, et cetera, and it doesn't encompass situations where there are restrictive contractual terms, et cetera. It seems to me that that's sort of, I don't know that that helps you very much from the proponent standpoint, because it's making the exemption more complicated and potentially open to different interpretations. I wonder if any of you could speak to that.
Well, let me just say that clarification is.
Sorry, Professor Halderman, real quick, just for the court reporter.
Yeah.
Professor Halderman, I can see you will have something you want to say.
Yes, thank you. Clarification is, of course, appreciated, although, as we pointed out, the overriding complexity of the existing exemption and the kinds of complicated legal queries that it raises, especially in things like the other laws provision, wouldn't be helped so much by the kind of clarification that you mentioned, Mr. Emmer. I wanted to just also mention on the question of lawfully acquired, just one example that has come up in my area of election security research in the last few years has been about the DEF CON voting machine village, which is a public event every year at the security community's largest annual conference, in which the public is invited to come for a weekend and engage in hands-on research on the security of election equipment. And the organizers of that event bring voting machines and other equipment that they've acquired on eBay, some that's been donated to them, some that participants have brought with them. And although they believe it to be lawfully acquired, they have no way of verifying whether equipment that's been, for instance, purchased on eBay was in fact resold after some breach of a contract. It's quite common that the sales contracts on voting machines will prohibit reverse engineering them, will prohibit further resale. And this has caused real uncertainty for the, and risk, and serious risk for the organizers of that event. So that's just one example. And looking ahead, this same kind of, say, contractual limitation on resale of voting machines is something that I worry will prevent further research that I would like to do, trying to understand and improve the security of voting machines that are being marketed today, which are virtually impossible so far to acquire secondhand because those contracts prohibit their resale. But if one were to be sent to me tomorrow from an anonymous source, I would love to be able to study it. But I'm not sure what my lawyers would say in terms of whether I was able to do that with the current scope of the exemption.
Can I ask you a follow-up question about the voting village? Because that is something the office has looked at. We cited it favorably as an example of making use of the exemption in the proposed rule in 2018. So that was referring back to 2 exemptions ago, right? So my question is whether, are you seeing any instances that the voting village was unable to make use of good faith security research because of Section 1201 since 2015? Because just in terms of what's the record to the office so far, it seems we're not aware of anything that needed to be held back.
I am not myself an organizer of the village, although I'm a close colleague of the people who are the organizers. So I can't speak to what they might not have done that they otherwise would have. But I can tell you that they agonized over whether they would be able to hold the village under the current exemption. But
I guess when the agency says this is an example of using the exemption, I'm wondering why they're agonizing.
Well,
do you have any insight?
The agency saying that this is a good example, but then saying that the equipment has to have been lawfully acquired when they don't know the ultimate origins of the equipment it creates an apparent contradiction.
Okay, thank you. Mr. Zambrano Ramos, do you have a question you wanted to ask? I see your hand up. And then Mr. Williamson, I did see your hand up. And then Mr. Troncoso, and I think I see Professor Reed. My screen keeps moving around, so I have a hard time keeping track of people. But does that sound right to everyone? Yes? Okay. Mr. Zambrano Ramos?
Thank you so much, Mr. Greenberg. This question would be for Professor Reed. And it's kind of an issue that's been interwoven in these discussions, and that's the idea of the administrative guidance language versus the exemption language. I'm just curious, in your experience with the security research community, there's a lot of different kinds of security researchers. How easy is it for the community to kind of use that language that's in the administrative guidance for their specific uses? And can you specifically talk about use cases where you may have security researchers in a university or one institution versus more independent security researchers? Thank you.
Thanks, Mr. Ramos. And I may defer to Professor Halderman and Mr. Adams to speak further on this question. But just to tie back to themes from earlier in the week, this dynamic of can we see clarity in the exemption language itself versus in the agency record, or the final recommendation from the register that comes out, or the final rule from the librarian has been a theme. And I think it's important to underscore that there are different communities served by each of these exemptions. Some of them quite small and quite tight knit, and then some of them quite large and quite diffuse and quite diverse. And I think this exemption presents an example of a quite large and quite diverse and quite diffuse community, for whom having the sort of guidance that for other exemptions might be filtered into the community quite readily, is going to be more difficult here, because there are different groups of folks who do research in the context of academic institutions. As Professor Halderman mentioned earlier, there are numerous independent security researchers. There are researchers that work in-house at companies of various sizes and various levels of sophistication. So I think it's important to underscore that this exemption is aimed at and important to a broader set of actors than perhaps some of the other exemptions. And Mr. Amer, to your point, I know the office is navigating some difficult tensions here in terms of trying to figure out how could we clarify this in the recommendations we ultimately put out. How can we deal with the specificity of the exemption? And we appreciate your efforts to get this calibrated. But I think this is one where you're contending with a complicated user community for this exemption, and so simplicity really reigns supreme here. Simplicity is really important for the long tail of researchers who take this exemption. And to the point Mr. Adams raised earlier, there's a lot of fear, and fear counts as an adverse effect under the statute. And sometimes that fear comes from folks who are just not well steeped in administrative law, or how to read a recommendation, or even how to read the CFR, and are relying on guidance, are relying on community norms, are relying on folk wisdom that sort of makes it around. And so I think it's really important in this exemption, to the extent that you can draw it in a very narrow way that says, hey, security researchers, are you doing good faith security research by a standard that I think everybody understands applies here? If so, don't worry about all these little caveats. In fact, we'd like to really dispel that fear, right? And you should tell your colleagues that do this work that this exemption is safe to use. And I think where Professor Halderman left us here is the having guidance buried somewhere in the recommendation doesn't penetrate all the way out into the communities that are affected here.
Okay, if there's any more to add to that, it was Mr. Troncoso and Mr. Scarberry next. However, I do want to note that we are already 11:50 and we still haven't gotten to sort of probably the more significant portion to discuss in terms of what is new in the record since that DOJ letter came in with the reply comments. And we do still need to get to the privacy portion of this panel. So if there's no real objection here, I'd like to move on to other laws.
Can I just jump in for literally less than a minute? I think I do want to respond to something that Professor Reed just said. I think part of the concern that we have about this exemption is that we do think it is sufficiently clear, but there seems to be an effort to intentionally misinterpret the 2018 exemption, making arguments that primarily might be read as solely, for instance. And I think proffering those types of arguments can lead to concerns in the security research community that the 2018 exemption is much narrower than it in fact is. And so I think we need to take a really realistic look at the 2018 exemption and not sort of allow for really wild interpretations of how it might be read to dictate sort of what
Mr. Troncoso, I can stop you there. I mean, the record is really clear on the fact that the proponents and the opponents just disagree with the meaning of the 2018 recommendation. So that's pretty well developed in the record. I appreciate everyone bearing with us on moving on to other laws. So let's just start with the proponents. Before we get to the DOJ letter, we're looking for any examples of litigation or legal threats made against security researchers that allege a 1201 violation in conjunction with a meritless violation of another law, such as, but not limited to, the CFAA, where the conduct at issue would otherwise be permitted under the existing temporary exemption. So I didn't see anything in the comments submitted. That doesn't mean I didn't miss it. There was a lot of reviewing going on, but I do wonder if there's anything you want to verbally add to supplement the record.
Mr. Greenberg, if I could respond.
Yeah, Mr. Reed, go ahead, or Professor Reed, go ahead.
And defer to my colleagues on concrete examples as well. But I'd take a little bit of issue with the framing of the question as being around lawsuits. Again, there's not a lot.
I said or legal threats, which does not necessarily mean, you know, that a lawsuit is being filed, but that it was, you know, threatened. But we don't need to hash that out.
Well, I mean, I think it's important to respond to, even if your framing is legal threats here. And I think this has been a thread throughout the day today. It's important to consider that the users of this exemption are often, in the case, as Professor Halderman often is, not simply of avoiding litigation, but of demonstrating that their conduct is affirmatively in compliance with the law, right? And I think a lot of our concerns here are rooted in a need for certainty that that the users of the exemption are indeed complying with the law, and not merely that they're avoiding getting sued. So I would urge the office to be thinking about adverse effects in that respect. The presence of litigation as a general matter of the type that we referenced earlier with Apple versus Corellium, around the trafficking exemption, that creates an incredible chilling effect for anybody that's doing research that is in that space. And so folks who are working with, whether it's university counsel or counsel to nonprofit organizations like Mr. Williamson, have got to go further. They've got to be able to say, we know that this is going to be safe and that we're not going to get dragged into court by somebody like Apple, who's going to put our organization out of business.
Sure, but just to interrupt, and apologize for interrupting you, but first off, we've been over Apple v. Corellium, and I do want to just warn folks, we have a limited amount of time. So the record is, we have a court reporter. We don't need to go over things we've already gone over. I'm looking for anything additional to that, and really examples, concrete examples or affirmative proof here of folks who are being chilled because of the other law's limitation.
I'd point you to the example that Professor Halderman raised earlier, and I think the other law's limitation is precisely part of that example, and that's a conversation that happens all the time. And I think you've got a plenty sufficient record, coupled with the Department of Justice letter to advance the removal of the other law's exemption.
Was there, from the proponent side, does anyone else want to add anything before we move to the DOJ letter? Not hearing anyone. So I'm going to assume everyone's familiar with the DOJ letter, but just in summary, what they said was they now support removing the other law's limitation for a number of reasons, which we can get to a little later. But just I wanted to start with what both proponents and opponents make of this switch or this reversal on DOJ's position. Let's start with Mr. Moore. Mr. Moore, you're muted.
Apologies. The biggest problem I have with the DOJ's submission is it ignores basic rules of statutory construction, and it doesn't reference them, account for them, or explain why those rules don't apply. Specifically, there is a presumption against extraterritorial construction. And so when a United States statute and regulation says, just
to be clear on this point, you're referring to where DOJ talks about the fact that the other laws might sweep in foreign laws where there's there's researchers working
That's correct.
them across in different countries here and somewhere else, and where those laws might be inconsistent with US law or even against US policy. Is that right? Or obscure?
Or obscure, or just, I mean, that is not how, as a general rule, I mean, there are, of course, exceptions. There are exceptions in the antitrust area, I believe. But as a general rule, you do not read them, and the copyright laws certainly have not been interpreted to have extraterritorial reach. So those kinds of things, I mean, that kind of thing suggests a bit of an overbroad, a well-intentioned but overbroad concern, and the type of concern that could easily be addressed through clarification rather than amendment.
Mr. Adams?
Oops, sorry.
Thank you, Mr. Greenberg. So my take on the DOJ's, I like to think it was a clarification of what they meant to say in 2018. But I think the way I read it is the DOJ saying we don't need this tie to DMCA 1201. We're confident that we're in our abilities to sort of take on the CFAA cases as we see fit, and that it is not necessary to tie compliance with that to a copyright law because we can handle it. We don't need that extra support either from DMCA 1201, and we don't think as proponents that DMCA 1201 needs that extra support or confusion from CFAA.
Can I ask you a follow-up to Mr. Moore's point about extraterritoriality? And I mean, I did notice that as one of the sweeping concerns of DOJ was that it was basically that and the point you just made, that it may not be really necessary. So is there any point you'd like to make contrary to what Mr. Moore said regarding the fact that courts are not likely to see foreign laws as applicable in this area?
Even if they don't, there are still plenty of laws here domestically that could complicate this issue, right? And so we appreciate the DOJ recognizing that research may occur across national borders, and that is yet another area of complication. But even domestically, we see this as a problem.
Sure, Mr. Williams.
Yes, thank you very much. I mean, we of course respect DOJ's opinion, but I agree that if the main problem there is foreign laws, I mean, I've never thought of foreign laws as being part of that limitation on the exemption. So if you need to clarify that, I don't think my clients would have a problem with that, and we would support otherwise retaining the limitation. I will say one important thing to note about DOJ's involvement here is that we often hear that there's this ominous threat of criminal prosecution against good faith actors. And I think DOJ's participation in this proceeding over time has demonstrated that that's just not realistic. DOJ is not out there looking to prosecute people who have done nothing wrong, who have accidentally violated this exemption. That's just not reality. And DOJ's participation, even though I may not entirely agree with their ultimate recommendation, shows me that they're taking their responsibilities seriously. They're not looking to file unnecessary cases, and the speculation and fear that's out there is stoked not by DOJ filing cases, but by something else entirely.
Can I ask a follow-up?
I'm sorry, go ahead, Mr. Amer.
Sorry, so I mean, I take your point on that score, but I think a question still is what work is the other laws provision really doing from a copyright owner's perspective? I mean, if the other laws still apply, and people are on the hook to know what their obligations are regardless, is there a need to tie that compliance to liability under Section 1201?
Sure, thank you for that question. I think if I recall correctly, DOJ discussed this a bit, and their recommendation in the filing was, remove it from the regulatory language, but insert it into the recommendation to make it clear to people that this exemption doesn't allow them to violate any other law. And so my view on that was, why change the exemption language that we've had for some time that clearly states in the body of the CFR that you can't violate other laws, and move it into what has been criticized today as an overly lengthy recommendation. It's in the regulatory language that other laws need to be complied with. I would also say that Congress included that language in the statute in a number of places, and DOJ acknowledged that. I think I have a different opinion than what they reached, in that they said, well, over time, maybe Congress shouldn't have done that. I think Congress was wise to do that. So that's a difference of opinion, but that's where we come out on it.
Sorry, go ahead, Mr. Amer.
Oh, sorry. Yeah. So, I mean, I think the response to that seems to be, well, the current regulation does more than put people on notice that other laws still apply. It ties coverage of the exemption to compliance with other laws, and so it raises the stakes in terms of 1201 liability for violations of other laws. So, do you see that as a legitimate concern? And could we, take DOJ's suggestion of just incorporating instead language in the exemption that says this doesn't obviously, free you from the obligation to comply with other laws?
Legitimate concern, yes. Justification for changing the regulation, no. I mean, I do assume and believe in the good faith of the folks who are putting forward these concerns. But as I said, Congress saw fit to incorporate this into the statute itself. And that indicates a preference that when you're dealing with exceptions to the statutory regime, you don't beg for other laws to be violated. And I don't think that it's wise policy making to separate the two.
So I want to get back. I want to get back in a minute to the issue of how it appears in the permanent exemption in 1201J. But first, I do want to clarify or put a finer point on what Mr. Amer just said, which is that the DOJ is not recommending, a carte blanche or a get out of jail free card with other laws. It's just saying, not saying that the 1201 exemption is a safe harbor from other laws, but saying that 1201 is not conditioned on compliance with other laws, but liability under those laws may still be a concern. And I don't think they were actually saying, unless I misread, to move the current other laws language into the recommendation language. They actually provided separate language they thought struck a slightly different balance. So I do want to hear from other folks who have their hands up, starting with Mr. Scarberry and Mr. Moore, what they think about that approach to the balance. And then I want to get to this issue of statutory construction and 1201J. And then we really do need to turn to the privacy portion of this panel. So Mr. Scarberry?
Yes, just to briefly address something there. As far as sort of the rules of statutory construction here, 1201 is somewhat of an oddity in that it includes this reference to all other laws. Obviously, section 106 doesn't include similar language, so it's somewhat odd that this language is included there. And we said we think DOJ's modification fixes some of the conditional problems we've identified, but we still maintain that there's no way the exemption could really be read to also be an exemption to the CFAA. Also, to briefly address something, I can't remember who said, I believe it was Mr. Williams, that we should confine this here to the language in the permanent exemptions in the statute. The purpose of this rulemaking is because Congress recognized that those exemptions would probably and most likely be insufficient going forward. And so simply sort of anchoring the language to how it exists in the statute makes no sense in that context. But I'd be happy to let Professor Reed and Mr. Adams expand on that point.
Well, I recognize your point that this is supplemental to what's in the permanent exemptions. I do want to get back to that question in a second, but first I want to sort of wrap this up on DOJ's proposal. Mr. Moore. Mr. Moore, you're muted.
Yeah, no, this is not my day for muting. My point will be extremely brief, which is, the more we start talking, that our friends have been discussing the problems with all these other laws, and to me that seems to pose quite a hurdle on causation. In other words, if all of these other laws are problematic and stopping this kind of research, and that they are somehow in the way, then the statute is not in the way. I believe the Copyright Office raised these concerns in 2018 at a minimum. And so, to the extent that that's a factor here, I mean, that is not, I don't think it's wise to broaden the exemption based on that. That's it.
Okay, so I actually had that question lined up because it is in our 2018 report that this is a consideration for causation. So I see Mr. Adams and Professor Reed's hands up. So if I can start with Mr. Adams and then Professor Reed, just your thoughts on this issue that if causation, if these other laws play into causation, that 1201 is not in fact the cause of the adverse effects. It's that this act of circumvention would violate some other law. Do you have a response to that, Mr. Adams?
Yes, and so my response is pretty simple, is that because they are tied conditionally to 1201, all these other laws become part of 1201 and are part of the problem here, right? And so severing that conditional link doesn't make them not a problem for researchers, right? Here's the way I think about this conditional link is that, tying all other laws to a temporary exemption is like sedating a wolf in the wild for scientific research, except the sedative stops working if you disturb any other animal, right? Disturbing other animals, including bears like the CFAA, always comes with its own risk, but it shouldn't cause the wolf to wake up and eat you, right? And so
I'm definitely not sure I follow the analogy, but I think I understand. I think the point you're trying to make is that you should be able to tinker with one without worrying about not the one being what bites you effectively.
Exactly. The legal landscape around security research is complex and tangled, but severing this conditional tie here helps to simplify the sort of legal analysis that researchers have to go through. If I could, I wanted to quickly respond to yes. Mr. Amer's question about what work this conditional relationship does is that it provides a world of other legal triggers for litigants who might like to use the DMCA, but there's actually no copyright infringement going on, right? And so it's, you can find any other violation of law and then proceed under DMCA rather than whatever that other law might be.
Why would someone do that?
Well, Mr. Greenberg, if I could put a finer point on it, I think that
Professor Reed, go ahead.
I think the trigger here is section 1203, which says any person injured by violation of section 1201 or 1202 can bring a civil action, right? So this takes the violation of any law, and indeed now that the Department of Justice has sort of suggested that extraterritorial laws might apply, that's a new concern to grapple with, but also thinking about the array of mundane and local laws that we might never think of. I think Professor Halderman brought up in one of the previous hearings the example of the electrical code. If I'm considering legal risk for violating the electrical code, I'm not worried about a company like Apple coming and suing me for violating the electrical code, but I might worry about a company being able to use a violation of something like the electrical code to drag me into federal court to seek statutory damages.
Does that raise a concern that the damage, the penalty can be disproportionate to what it would be under the other law. Is that what you're saying?
Correct. I mean, we could be talking about minor civil violations with small or no fines. There could be code enforcement and I think also I would tie it to the level of risk, right? Or you'd say that the likelihood of a local code inspector ever even knowing about something like that is low. But if you've got a very motivated opponent who is looking for things, and you say you want to shut down this security research, go find any law that they have violated at the local, state, federal, or international level during the course of their research. That's a much tougher risk calculus to deal with. I'm sorry, Ms. Smith.
Can I just probe the 1203 point for a second? So since this is like mirroring the statutory language and regulatory exemption, are you aware of any threatened or actual litigation brought by, I don't know how you would describe this universe, but let's say universe like the electrical code purveyors who kind of get into 1201 land because of this limitation that has been brought? Is this a real concern?
It's a real concern for people who are doing, and perhaps somebody like Mr. Williamson could speak to this. This is a real concern for people who are providing legal advice, because the range of questions that they've got to answer is not simply, are you doing good faith security research within the metes and bounds of Section 1201, but is everything that you are doing consistent with every other law at every other level of abstraction? And that's the issue.
Sure, but I think my question is, in the 23 years of the DMCA, have we seen Section 1201 being brought on, added to a state law claim or a foreign law claim or something else where otherwise you wouldn't normally think it would be implicated because of this provision?
I mean, again, to the point that's raised earlier, we've seen relatively little 1201 litigation. And again, we're operating here around the need to affirmatively demonstrate. And I see my colleague, Mr. Reed, raising his hands here. I would say
gesticulating.
No one wants more lawsuits here, by the way, to the point earlier. But we're dealing with people who need to affirmatively demonstrate that their behavior is sufficiently not risky, for example, to get the go-ahead from their university or their company to move ahead. And when somebody like Mr. Williamson is giving them advice, you might well say, hey, look, if I've got to justify that you are complying with every single other law, I cannot bless you doing this, given that you're like.
But again, the question is, are researchers being told that by university counsel? Are they being told, are they being told, not, I can't say whether or not you can do this, but I actually am telling you as the legal counsel for your employer that if you do this, you will not be covered by the university or protected by the university?
I might defer to my colleague, Professor Halderman or Mr. Williamson on that one.
Professor Halderman, do you want to have a response, or if not, Mr. Williamson?
There's only, this is Professor Halderman. There's only so much that I can say about the content of conversations with university counsel, but I will say that I will say that it's this has been a dimension of conversations that I've had. Just speaking personally.
Okay, I probably can't. I hear you just saying you can't really say more than that. Mr. Williamson?
I'll speak to a comparable limitation, which is in the reverse engineering exemption, the lawfully obtained language, which I think in a similar way sweeps in other laws, because you have to ask the question of, what law might you have broken in obtaining this thing? And so I have certainly advised developers who were reverse engineering software in a way that would otherwise have been exempt under the exemption, but there was a concern as to whether they might have violated terms of service or simply breached contract, and what other laws might count and how minor a violation might then give rise to CFA liability is a real concern and has been a point of advice.
Okay, before we move on to the last thing I wanted to ask about with regard to the statute itself, but I do want to just ask again what Ms. Smith mentioned, and particularly to you, Professor Reed, since I know you're really well versed in this and have been working in this area for many years, as have many of you, I know. But the fact that after 23 years, we've seen so few cases regarding the security research exemption generally, what does that tell you about how well the exemption is working? It would seem, I mean, we hear in this context often that if something isn't resulting in litigation, it must be because parties have figured out a way to make it work.
So I think the way to read that is twofold. And I'll go back to my remarks at the beginning just very briefly to say, one, the office has significantly broadened the scope of the exemption since 2005. And in tandem, the degree of security research and the degree of cybersecurity as a national both threat and policy priority has increased pretty commensurately. So I think what we're doing each time we come to this exemption is bringing to you the increased seriousness. And I think we're in a very different place than we were 15 years ago in terms of the type of research that's being done. And so I think, one thing to read that is the office's continued broadening of the exemption has been helpful. I think the other way I would read this, and I would broaden this to section 1201 generally, is as you're considering the balance of the equities here, consider that section 1201 is basically never used by the opponents of the exemption in litigation against, as far as I can tell, just about anyone for just about anything. So that the equities on the other side are fairly marginal here. And particularly because copyright infringement is always available as a remedy, as are the other laws that we're talking about here if they're indeed violated. Though, because of the way that 1203 operates, they may not be available to the same people. And so that may raise a different.
Opponents have anything they want to say in regards to that, since that did sort of sweep in their equities? If not, yeah, Mr. Moore.
Just that some of this discussion has been a bit confusing to me in terms of basic concepts of Article 3 standing, and how one, standing, two, concepts of fair notice that are routinely imported into the construction of statutes. Again, there are aspects of this discussion, I think, where Mr. Troncoso's earlier comments about the wide range of hypotheticals that come subject to this proceeding are particularly apt. That's all.
Okay. All right.
Can I just follow up quickly before we move on, not to belabor this, but I mean, can you or any of the other opponents give an example of what sort of work this provision is doing that is relevant to copyright? I mean, if we're being told by the agency that enforces these statutes criminally that this link is not necessary to protect criminal enforcement of the CFAA or any other relevant law outside the copyright context, what's the best argument for retaining it? Yeah, Mr. Williams.
Thank you. I mean, I think it's hard to come up with every potential hypothetical, but there are related statutes that are of great import to content creators and distributors. One would be cable and satellite piracy, for example. And the DMCA was passed after the statute that covers cable and satellite piracy. And there's a lot of cases, if you go looking out there, there may be more cases actually under the DMCA related to this than any other issue about cable and satellite piracy. And so that's one example of another law that does have a content-based focus that is complementary to the DMCA, and that I don't see a harm in requiring compliance with both in order to get the benefit of this exemption. There's probably more examples out there, but I don't think it's fair to say that all of the other laws that could be violated have no relationship to content protection, including the CFAA as well.
Thank you, Mr. Williams. I am going to move us on to one last question on this and then into the privacy issue. And this is because we already touched on this and I said we were going to come back to it. But to the proponents, I wanted to ask, because several of the opponents noted the similar language in 1201J regarding other laws. And the office in 2018 said that it believes it's generally appropriate for the exemptions to track the relevant statutory language where possible. Obviously, at the same time, as was noted, this proceeding is supplemental to the permanent exemptions and is designed to fill gaps where a need may have arisen that Congress didn't foresee. So the question the office has is, why shouldn't that principle continue to apply, that principle of tracking the relevant permanent exemption language where appropriate? And do you find a problem with the registrar recommending temporary exemptions that use broader language on this limitation than the permanent exemption?
This is Blake Reed. Mr. Greenberg, could I ask you to clarify what you mean by broader in the last question?
Yeah, broader in terms of it maybe would remove some of the limitations that would be in the permanent exemption.
Absolutely. So I'd first note, I think it was 12 or 13 years ago when I was first asked about 1201J, and we've established many times over the years the infirmities and shortcomings of Section 1201J, and I would note that those are baked into the office's renewal of the existing exemption. The scope of the current exemption importantly goes beyond 1201J in a whole range of respects, and so I would suggest that as a general matter, that's a settled question that hasn't been properly noticed in the current context that we're in, whether it's appropriate as a general matter. I think it's well settled, and I think proponents and opponents alike have stipulated to that. As to the specifics of the exemption, I think Mr. Scarberry pointed out earlier exactly the point here, which is Congress didn't know in 1998 what sort of a world we would be living in. I think if you said to the drafters of the DMCA that we would be dealing with foreign actors conducting cyber attacks on electronic voting machines, and that copyright law was somehow going to be in the mix, I think they would have been quite horrified, and I think they might have drafted the DMCA in a different way. The one wise thing that the drafters of the DMCA did, or one of the wise things that the drafters did, was they put in this triennial review process, and quite explicitly in the legislative history at several points said the purpose of this is to exercise some humility here and understand that the world that we're living in 1998 may not be the world that we live in for the duration of this exemption. And so I think the sort of calls to import pieces of the permanent exemption, whether that's 1201J or 1201I or G or F, are appropriate insofar as only insofar as the current world that we live in bears any resemblance to the world that we lived in 1998. And I think I can pretty unequivocally say, and I'm sure Professor Halderman can speak to it in greater depth, that with respect to security and with respect to the kinds of security threats that we deal with and the important role of independent security research, that the world we live in today looks almost nothing like 1998. And so continuing to call back to the statutory exemptions, I think they are effectively, relative to the temporary exemption, we've so far moved past them in the last dozen years of this rulemaking that I'd urge us not to go back to them. I don't think they have much relevance here.
Thank you. Professor Halderman, if I could just ask you to briefly, and I really mean briefly, respond to what Professor Reed just said about how much the world has changed. And then I want to go to Mr. Taylor and Mr. Williams. If your hand is still meaning to be up, it's not. So Mr. Taylor, and then I want to move on. So Professor Halderman, is there anything you want to quickly add to what Professor Reed just said?
Well, just Professor Reed is exactly right. The world looks completely different today in terms of cybersecurity threats and in terms of the shape of the defensive community, of how much we are relying on a broad community of academics and individuals and companies to keep all parts of our infrastructure and society safe.
And this,
So,
I just want to really quickly, I'm sorry, I didn't want to ask this, but I do now. Causation, though, remains an issue, right? So you're saying that circumvention is needed to do the research that you and others want to be doing, that is needed in the 21st century. It can't be done through other means that don't involve circumvention?
often that's the case, yes.
Okay. Mr. Taylor?
Yes, real quick, I would just point out that when you ask about whether or not the statutory language should be imported into the exemption, I would just go back to the purpose of this rulemaking. The prohibition is a broad prohibition. The permanent exemptions are fairly narrow, and the exemptions that you're supposed to create in this rulemaking are supposed to be on evidentiary record. So if there is no compelling reason to remove the statutory language, then that's because the proponents haven't proffered enough evidence.
Okay, thank you. So I want to move on now to privacy. I do want to make sure everyone saw in Software Freedom Conservancy, did I get that right? I believe I did. In their reply comments that they originally had made a proposal for a temporary exemption. The substance of the exemption didn't really change, but in the reply comments, they did take the position which had been suggested by some of the opponents that it really belongs in a different request for a different temporary exemption. So just want to make sure everyone's aware of that. And then I just want to ask a few questions regarding the substance of the exemption itself. So several of the commenters said they opposed the privacy exemption for security research because the current exemption already covers privacy research. DOJ and Rapid7 both basically said, understood correctly, the current good faith security research exemption covers the type of privacy research that Software Freedom Conservancy was asking for an exemption for. And Consumer Reports said that they were in support of the office simply clarifying that the current exemption already covers this. So maybe they didn't think the language was clear enough in the registered recommendations, but that the regulatory language itself should and did. So to what extent does the current security research exemption cover these uses? And to be clear, Software Freedom Conservancy asked for support to cover not just privacy research, but permitting the disabling of functionalities that enable a product to obtain access to personal information. So if we could start with Mr. Williamson, I'm curious your thoughts on to what extent the current exemption covers that, and then some hands.
Sure. So, what we pointed out in our initial proposal is that the security research exemption, requires this nexus to a security flaw or vulnerability, and we gave examples of a couple of specific, sort of privacy research publications where the researchers were effectively researching whether personal information was being disclosed in a way that was not necessarily insecure, but was otherwise violative of privacy. For example, it was contrary to the product producers' disclosed privacy practices. And so our contention there was it was not clear that these issues could be called security flaws or vulnerabilities. Now, I also want to exercise some humility here. Software Freedom Conservancy represents the interests of users of products and software. We do not necessarily represent the security research community directly, and I recognize that there is expertise on this panel that we don't necessarily have, and so I'm certainly would like to give proper deference to the opinions of those who are in the weeds doing this work.
So I do want to hear from others, but I do actually ask you one quick follow-up question, which is the request asking for the exemption to cover disabling of functionalities, et cetera. That has some historic comparison in the phone unlocking situation. But the justification for allowing circumvention for this purpose was not clearly spelled out in the petition or the subsequent comments that were filed. So can you just clarify the rationale for why that would be justified under the Triennial rulemaking process and under this exemption?
So, I think that we distinguished in our initial comment that, we recognized that consideration was really more relevant to the permanent statutory exemption at Section 1201I, and that this process probably wasn't the appropriate place to discuss sort of individual remediations of privacy issues. And so, that was sort of our position, was that we were focusing on the exemption for researchers, and we made a sort of general recommendation to the office to consider some expansions to 1201I as a sort of recommendation to Congress, but we recognize that that's not something we can really address here.
I'm actually kind of wondering if we can resolve this pretty easily. I just wonder if it sounds to me, and I did see that in your comments, but like you would support removing that portion of the requested temporary exemption, and just we could clarify the language so that it would cover the type of privacy research that that DOJ and Rapid7 and others are saying already is covered by the current good faith security research exemption. Would that be an accurate framing of your position on this?
Yeah, if the office was willing to clarify that these activities that we've outlined are covered by the existing exemption, then I think that would cover our concerns.
Okay, thank you. Mr. Troncoso, do you have thoughts on that? I know actually BSA was cited specifically in their comments as being supportive potentially of this as a separate exemption.
So I think that it is certainly deserving of consideration, and I think we would need to look at a fulsome record to really put a finger on sort of the scope of what that sort of exemption would cover. I do want to flag some concerns with the Software Freedom Conservancy's reply filing and that sort of language that they highlighted as a potential path for creating a new exemption. If you look at that, the language that they've suggested, it would allow for circumvention to remove functionality in any software program that collects or disseminates personally identifiable information, regardless of whether that is functionality that the user of that program is made well aware of. So this is not necessarily like a flaw in the program or a vulnerability in the program. So, I take the Software Freedom Conservancy's point that there are certainly instances where there are flaws in programs that are making people's personally identifiable information available in ways that neither they nor any reasonable user would expect. And we want people researching that sort of thing. But the language that they've proffered here would be a far broader exemption than that.
Yeah, I do want to follow up on that, Mr. Williamson. To what extent is the problem here caused by anti-circumvention prohibitions, and to what extent is it about market decisions, and is there a market solution? Right, you walk with your feet. As a consumer, you just don't use the cell phone company that's selling all of your data and all of your geo tracking location information. You go to a cell phone company that's offering you more privacy.
Sure. Well, I first like to point out that I think the language being referred to is in our initial comments and not in our reply. Our reply was based closely on the security research exemption. We addressed this general point that privacy concerns in the U.S. are sort of generally addressed by this. You've got notice and choice to choose the products that you think will preserve your privacy. I think what history has borne out is that consumers are not well equipped to make these judgments sort of a priori. It tends to be after security researchers, privacy researchers have gotten in there and demonstrated issues. So I think of, for example, the Samsung television that responds to voice commands, and a lot of people bought it and then were surprised to find out that what responding to voice commands means is that there's a constant stream of voice communication being reported whenever, all the time, and being sent back to Samsung's computers somewhere, right? And so even where the feature itself is sort of just well disclosed, and you could say they had notice of it, it's not clear to most consumers what that actually means in terms of privacy concerns. And so I think that it's not sufficient to protect consumers.
Okay, Mr. Reed. And then Professor Reed. Mr. Reed, you're muted.
I think I'd love to see what Mr. Williamson's text is, but he does point to something that we're all working on and considering, which is the differentiation between what's disclosed in a notice and consent regime, where in fact people are consenting to something they're not aware of. So like Christian, this is something that our industry is obviously very attentive to. And it's worth recalling that the FTC has oversight over this under unfair and deceptive trade practice. But to Mr. Williamson's point that I'm sure he would make is, but if we don't know that that's happening, then we can't go to the FTC. So I want to make sure whatever exemption that they're requesting is limited to the ability of security researchers to help find that and to work with industry to discover those problems, as opposed to the original proposal, which also included the ability to make tools that would essentially disable functionality. That creates its own separate problem. So we're probably in a place where we may be able to agree. I'm caveating that, but I think Mr. Williamson raises points that I think all of us on the software industry side are very well aware of and are participating in this kind of industry shift away from a consent regime that doesn't reflect what people are accurately consenting to. So I'd love to see the final language on that so that we may be able to support.
Can I just ask, do any of the opponents disagree that the current good faith security research exemption covers good faith security research for the purpose of detecting privacy flaws and things like that?
No, we do not disagree.
Mr. Troncoso, I saw you nodding your head. BSA does not disagree with that either?
I don't disagree.
I think on this we may have a point of agreement that we could clarify or solidify through a post-hearing letter. So we may follow up on this. I need to talk with my colleagues on that. This is my first time doing this, so hopefully I'm not speaking out of turn. But it is nice to hear the proponents and the opponents sharing some agreement on this point. Unless there's anything, I guess Professor Reed, I see your hand is still up. If it's brief, I'll know we're almost 10 minutes over. But if it's brief, you wanted to add?
I'll note that Mr. Scarberry and I are late for my class, so I'll be very quick and say that I think we're largely in agreement as well with the position that Rapid7 has struck out, that the security exemption largely covers the kinds of privacy researching activities that have been discussed. We would urge, if the office were to take a different result, to recall that the scope of the term security has been recommended for renewal in the existing exemption, so that it should take great care not to suggest any narrowing of that term that hasn't been properly noticed, and our comments solicited on it, which would potentially give some rise to some APA problems. Thanks.
Okay, thank you. So with that, I'm gonna dismiss us all for lunch. I know a handful of us are getting back on this in about 30 minutes probably. So thank you all for being a part of this session. I hope it was as much fun for you as it was for me, and it was definitely very informative to have you all helping us fill out this record. So thank you.
Thank you to the Copyright Office.
Thank you.
Thanks.